SJC-13458, Commonwealth v. John T. Cappellucci, Jr.
Okay, Attorney Johnson, whenever you're ready.
Thank you, Your Honor. May it please the court. Good morning. My name is Melissa Johnson. I'm an assistant district attorney in Middlesex here on behalf of the Commonwealth. With me at council table is ADA Daniel Balkin, who is the trial ADA and hopefully will remain so if we can get this case back on track. And so today we are asking this court to reverse the motion judge's allowance of the motion to suppress the state police toxicology results of the defendant's blood that was procured by the hospital for medical treatment purposes and later seized with a search warrant based on probable cause. Now, I would reiterate some of my arguments that my colleague from Essex County, I believe we have pretty much the same arguments as it goes to OUI, SBI. And the canons of statutory construction that dictated the results in Bohegan and Emerald.
Judge Kunis
Yes.
found the, what Ms. Moriarty left off, Judge Kunis found the opposite, right, about the absurd result. Can you explain that to me and who do we?
I wish I could explain completely why he found that way, because he said we were technically correct, and I'll take that. He just thought that the result was absurd and unworkable and unfair, which I haven't.
It has to do with where the statute lands. Does it protect defendants charged with crimes, or does it affect the public where the defendants charged with more serious crime, correct?
Right, and I think you hit on it just on the nail on the head, Your Honor, is just this is a situation where the legislature, within its purview, decided to balance the rights of the driver or defendant against the rights of the public and the public's interest in public safety. Because there's, in those, and I don't want to call them run-of-the-mill OUI, simple OUI liquor cases, because nothing is run-of-the-mill about it, but simple OUI, the defendant will enjoy the right to consent to a particular blood test, whether or not he's in the hospital and the nurse is drawing it or the doctor is drawing it, or whether or not the police are directing it. It's the defendant that enjoys that in that simple case. But with a situation where it's more serious, an OUI SBI, an OUI drug, something that is a little bit more complex, in that case, the legislature has every right to decide that.
Where there's a victim.
Where there's a victim, or if it's an OUI drugs, which I'd like to discuss in a minute. It is, the legislature has the right to decide, you know, the police should investigate this. They have the right to pursue an investigation and apply for a search warrant based upon probable cause and seize the evidence if they can meet that standard and continue on with their investigation. It's balanced that right, and you can see it in the plain language of the statute. That 1A was, or I should say paragraph A, that language was left alone for decades, beyond the time that 24L, the OUI SBI statute, was enacted, well beyond that, just was left alone. And if you look at the landscape of Chapter 90, all of those, not all of them, but most of those sections, the one right before, the one right after 24, they're all mentioning specific offenses and what applies in that particular section. They never did that with 1E. They never bothered to do that. And that is a sign that the legislature simply wanted to leave that balancing in that particular section for the defendant. For just
both of these cases deal with obtaining a blood sample after medical treatment, correct?
Yes, I believe so. The one before me, yes, Your Honor.
Right, and certainly yours.
Yes.
If we rule in your favor, does it allow a police officer to take blood without consent, absent the medical treatment?
I'm sorry, absent?
Absent medical treatment.
So are we talking, Your Honor, about the 1F situation? Right. No, Your Honor. I believe that 1F is really a situation that talks about the blood drawing, the initial blood draw.
That's still verboten.
That is, Your Honor. This would not affect that Because if you think about it, and you read Bohegan, it's really talking about that initial blood draw, and that would apply to any OUI liquor offense. Simple, beyond that, because the whole policy reasons that statute enacted was to prevent that original kind of confrontation between the
Right,
suspect.
which we discussed in Bohegan.
Right,
But
right.
let me ask you though, so the entire universe, to your knowledge, of these cases involve post-medical treatment, obtaining blood?
Yes, for 1E, I believe that 1E is really dealing more with the admissibility of the blood after it has already been drawn. So it is uniquely applicable to a situation like this where the hospital has drawn the blood and then the police want to go in and say, may I test it?
And you've already won the state action part of the
Yes.
motion.
Yes. So, so that is the difference between the two. I think 1F definitely is governing the initial blood draw, and which could be applicable to other OUI liquor offenses, versus 1E, which really, as Justice Lowy had hit on, is the admissibility of that particular evidence in a prosecution for simple OUI liquor.
I can't remember exactly where I read it. It might have been in Judge Kunis's opinion, but I think somewhere I read, don't worry about it, this is no big deal, because if the blood was taken for the purposes of treatment, diagnosis and treatment, then you got the medical report, you can just call an expert to do a conversion. Did I read that somewhere?
Yeah, it's
Yeah,
in
that
his
was
case.
Justice Kunis's
Okay.
memorandum, Your Honor. I have a couple of responses to that. Number one, just because we can get that evidence from somewhere else doesn't mean that we're not allowed to get the evidence through this means.
True.
And nothing in 1A prevents us from doing that. That's our argument. The second argument, there's some practical considerations with that. Number one, the type of diagnostic test that the hospital is using, we have no control over. We have no control over the reliability. It might be a rapid screen if it's an emergency situation. We might not be able to use that later in trial because of the reliability. And the other issue is that we don't know what substances they're testing for.
But you're not going to get the fentanyl.
Exactly, because they are testing it for a specific purpose. So we have no control over it, and it will be helpful, certainly, Your Honor, absolutely. We will use the medical records and get the conversion, but there's nothing like having the state police test for certain substances and for alcohol in the precision that we require for something to be admissible and probative.
Can I just make sure, is your understanding that Moreau, you couldn't use it, you couldn't use the blood draw because it was simple OUI?
Yes, I believe that the language said it was, that was the reason why 1A was applicable and why the consent issue was at play there was because it was a simple OUI.
And
There,
so
I think it
here-
was a single car crash with the defendant.
And so here, because it's with serious bodily injury,
Yes.
same type of blood draw, but different prosecution, different charges, so you can use it.
Exactly, and this is precisely what Bohegan had basically envisioned. This is an OUI SBI. It's a more serious offense. It is not listed in 1E as a case where we would require the defendant's consent to the analysis of the blood already drawn. So in that sense, the OUI SBI, that's what takes it out of Moreau, because it is a more serious offense. And the other issue that I wanted to draw on, which my sister, because of her case, I'm not really sure if drugs were at play there, but the OUI drugs issue, we do have OUI drugs SBI, and I don't think that particular issue has been addressed by this court. And it is our position that neither 1E or 1F, which is an issue in my particular case, but neither of them apply to OUI drugs or the testing of drugs. There's nothing in the language of either of those statutes. They were enacted for the purpose of both of the drawing of blood for the purpose of obtaining blood alcohol content and the admissibility of that blood alcohol content for the purpose of determining whether someone was under the influence of an intoxicating liquor. There is nothing in either of those sections that refers to OUI drugs.
But it's okay to forcibly draw blood from somebody if you're looking for something other than alcohol?
Well, Your Honor, with a warrant or upon probable cause and exigent circumstances, we know that that's constitutional under Bohegian, that was discussed, and there's no statutory overlay that we had it with 1F or 1E that would prevent it. So it is constitutional with a search warrant or, as I said, exigent circumstances in that situation if you were looking to obtain evidence for OUI drugs. So yes. So our position is that those sections do not apply to OUI drugs. If the legislature wants to enact something specifically for that, that is their purview. But in this case, OUI drugs is not at play in terms of these statutes.
So all the protections on Bohegian and 1F are out the door.
Yes.
Right, but your backstop is the Constitution.
Yes, absolutely. That is always the backstop, is the Constitution, as it is here in 1E in our particular case. What's driving the admissibility
If the
of...
person doesn't want to have the blood drawn,
What's that?
so there's probable cause, there's exigent circumstances,
Yes.
and the person's thrashing in the bed. Hold them down?
Well, Your Honor, if there's a search warrant upon probable cause, that is essentially what the Constitution requires. So yes, that is what happens. And that is probably what drove part of the holding in Bohegian. It was that a recognition by those are situations where we do want to avoid, absolutely. But there's nothing in the Constitution that prevents that from happening. And as Justice Wentland said, that is really the backstop here is the Constitution. It's not as if the defendant has no protection here under 1E in our particular circumstance. We still have to show that, like any piece of evidence that was seized by the police, that there was probable cause, and here we obtained a search warrant from a neutral and detached magistrate based upon probable cause, or that was exigent circumstances. So it's not like the defendant has no protections here. There's just not some kind of statutory overlay, which in Bohegian and Moreau, where this court said, well, okay, it is constitutional, however, there's a statutory...
The entire statutory scheme either says alcohol or intoxicating liquor. The word drugs are nowhere in it.
There's nowhere in it for drugs. And I do think, if you think about it, to me, it's a recognition that how extraordinarily difficult it is for...
Speaking of recognition, is also the fallibility of the DRE experts, right?
Yeah, I mean, I think it's extraordinarily difficult to prove these cases for us unless we have some sort of toxicology report showing exactly what this person had ingested in terms of drugs, because under our statute in Massachusetts, we have to identify the exact drug. We know this guy is on something, and we know by the way he's driving that he is on something, but we have to prove the exact identity of the drugs.
Yeah, I don't know if you get much sympathy for that. So you get to strap somebody down and take their blood because you have an element to prove in your case? I'm not sure about that. Can I ask you, though, a different question, the same one I asked your, well, I guess it's the prosecutor in the other case, which is why is not a prosecution for a violation of simple OUI subsumed within a prosecution for violation of aggravated OUI?
Your Honor, I do believe that flies in the face of the canons of statutory construction. It has to be listed within the statute itself or
That's
refer to
what canon
elements.
says that?
The canons that dictate that the plain and unambiguous
Right, that's why I'm
language-
focusing you on the plain and ordinary language of the statute, which says a violation of simple OUI. And my question to you is, why isn't that also a violation for aggravated OUI? You've got the same elements that you have to prove.
Because it doesn't say a violation of simple OUI. That
Because
was
the
my
indictment
paraphrase.
doesn't say that? Is that why?
The statute says the violation of paragraph A.
Right.
And there could not be more clear language. Go back to paragraph A and look at what's charged there, and that is simple OUI, or straight OUI without anything. And that is the plain language of the statute. And as I had said before, if the legislature had wanted to add offenses in there, they could have done that. If they wanted to add substances in there, they could have done that. They had plenty of time to do it, and they haven't done it. So to me, the plain language of that statute is the best evidence of legislative intent. And that's what we have here. Their intent to leave it alone and balance the rights of the defendant driver in a simple OUI case against the defendant driver in a much more serious, complex situation where victims are involved and their injuries or death are involved. And that's the balance that the legislature is entitled to make. I'd ask this court to reverse the motion to suppress ruling. Thank you very much. Unless there are any further questions, I'll rest on my brief.
Thank you.
Thank you.
Okay, Attorney Hellwig.
Good morning, Madam Chief Justice, members of the court. I'm Mark Hellwig. I represent John Cappellucci, and I'm asking that you not overturn Judge Kunis's decision. I suggest, again, all of the issues about, when I cite Roth, that when you're prosecuting under an aggravated, a lesser included is also being prosecuted, it's impossible to take the two pieces apart. And I don't want to repeat what everybody else has said, but I'll just point out a couple things. Section 1E is the section that allows the government to get in. We're focusing on the provided that part that says it has to be, there has to be consent. But Section 1E says in any prosecution under Section A, that the evidence of the weight of the alcohol of the defendant's blood at the time of the alleged offense, as shown by chemical test or analysis, shall be deemed admissible and deemed relevant. So if we're getting rid of 1E for the provided that section, we're going to get rid of 1E for this section. So I'm not sure.
Heck with the rest of the law of evidence, that the relevance of what the blood is and the authentication required to put in that evidence isn't available anyway?
Well, I'm not sure if it's available, but I think it's going to, now we're going to have some, there's going to have to be some sort of basis. The reason that
How about the relevance of the forensics of how much alcohol is in the system?
I think that there still might have to be some sort of expert analysis for that, to put that in, whereas here they can just put it in because the statute says
I thought
it
you
can.
were saying, well, since it says that, without it, it wouldn't be admissible, so it makes no sense.
Well, that's what I'm saying.
The statute doesn't eviscerate the rest of the law of evidence.
Well, I guess I understand, but what I'm suggesting, that would mean that this paragraph wouldn't apply to an aggravated OUI, and so.
And I guess, what's the point? So
My point.
Let's just say it doesn't.
Well, so if it doesn't, I think that it makes it harder for the Commonwealth to prove an OUI.
Right, they just have to go to the rules of evidence, the guidebook, and figure it out how they're going to get it in.
Yes.
Okay.
Okay, but I'm just saying there's two pieces to it too. It's a sword for the Commonwealth as well as for the defendant. But the Commonwealth, I'd suggest, if I was arguing that they would need to have some sort of Daubert evidence, some sort of expert to get it in, they would say, as Judge Kunis said, that that would be absurd and unfair to the Commonwealth to have to do that, to use where the legislature says that they can use this evidence in a case like this. And so what I'm saying is that's the same piece, that this piece is the same piece, is the same part of the statute that I'm defending. And so I'm suggesting, again, my main focus is that you can't prosecute, as you had indicated, you can't prosecute a aggravated without including the lesser included. So they are prosecuting a lesser included. So the plain language doesn't exclude it. It's at best.
So your best case reading of E is that it's ambiguous. So tell me why you win anyway.
If it's ambiguous?
Yeah.
If it's ambiguous, I should win because of the rule of lenity I put in my where it's not clear. Well, first of all, I suggest the purpose of the statute.
Clear in isolation, but you look at the rest of the statute as your opposing counsel has, and there are places where the statute says elements. There's places where the statute says, specific violations, and here it doesn't. And doesn't that tend towards the prosecutor's version of the construction. It's not, it's ambiguous in isolation, and I might grant you that. But if you look at it in the context of the whole, I think that gives more clarity to the language.
To me, the ambiguity is because of the lesser included, because it's not clear. I mean, are we prosecuting under this or are we not? Because you kind of are. And if it does apply, then it should apply, and the judge was right. I think that's what I'm saying.
Okay.
Counsel, if you could help me, I don't see this argument. They're two separate crimes. Okay, so the serious SBI subsumes elements of simple OUI, but why does that mean that it's one and the same? They're separate crimes.
Well, I cite the Roth case.
I know you cite the Roth case, but back to Justice Lowy's point. So just because after the presentation of evidence, the Commonwealth may not necessarily win on the additional elements and the jury comes back with a lesser included, why does that necessarily mean on the front end that it's the same, it's for the purposes of the construction of the consent, it's the same crime, it's the same charge? It's not the same charge.
So I'm not suggesting that if there were different language, it could be clearer. I'd suggest it's not clear what this means. Even though the Commonwealth keeps saying it's clear, I'd suggest it's not clear because of the way that the prosecution works and the fact that you could be convicted of 1A. If you can be convicted of 1A, they must be prosecuting you under 1A. Or I don't see how you could be convicted of a crime they're not prosecuting.
So when they prosecute someone for murder 1, they prosecute them for manslaughter?
Yes. And assault and battery.
Assault and battery, too.
And so
you tell your client, you've been charged with assault and battery, and murder?
Well, no, I'm not suggesting that, but what I'm suggesting is these are special rules dealing with OUIs. If you were charging someone with something, and the Commonwealth said, I mean, these are, if there was a different charge, if it was a murder charge, then they could go and get a warrant and take these things. But the purpose of the statutes here was to protect people's privacy rights and not to have to consent.
Well, let me ask you a different question on the drug part of it.
Yes.
What's your position? There's nowhere in the statute, in any of it, does it say anything other than alcohol or intoxicating liquor. Do you want us to read in the words drugs?
Well, it says no such test or analysis shall be made. I'm not sure, I mean, yes, I do want you to.
Okay.
Because I don't see how you can separate realistically the two and say, if we're not.
It would require us to read the term drugs into a statute that doesn't say drugs, right?
Well, I think it would require just a blanket. They can't test the blood that was taken without the consent of.
So these are statutory protections as opposed
Yes.
to constitutional, right?
Yes. But it still says, I mean, again, I think in 1E it says no such test or analysis shall be made, or it might be in 1F. I look at, and I'm sorry, I don't see. I look at 1F and 1E as the same rule. I don't look at them as separate, because in the one of the cases, that Carson case, the Chief Judge Armstrong dealt with them as 1E and 1F. And when you take a look at them, 1E is saying the government can get in blood alcohol level, except unless someone doesn't consent. And then 1F says that everybody consents to a blood test by driving on the roads, except they can't force you to.
So basically, you're saying that because it's an OUI and it's an OUI drugs, all of the OUI protections statutory apply equally to alcohol and drugs?
Yes, that's my position. And
It'd take a lot of rewriting.
Yeah.
well, to me, I just don't I think as a practical matter, it's difficult to separate the two.
Well, that may be true, but that's not what the statute says.
Thank you. I'm not sure if there's any other questions. I'd rest the rest on my brief.